Good evening, ladies and gentlemen. Smithtown Planning Board is now in session. Would you join us in the pledge? Jim, would you lead the pledge?
I pledge allegiance
To the flag of the United States of America, and to the republic
for which it stands,
one nation,
under God,
indivisible, with liberty and justice for all. We thank you.
Jim.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 1, Item 1, number 2011-01, All Seasons Motor Lodge. Item 2, number 2011-10, Anthony Lettieri. Item 3, number 2009-05, FB4 Realty. Item 4, number 1059, Prestige Estates. Item 5, number 1000A, Soundview Estates. Item 6, number 773, Scholar Estates. Item 7, the 280A application of Olivia Estates. Item 8, the letter of interpretation for the Polish National Church. Part 2, Item 9, number 2010-06, KVC Holdings. Item 10, number 1053A, Berg Estates. Item 11, number 911A, Glen Hill Northern. Mr. Chairman, these are the items the Planning Department recommends for adjournment.
Is there anybody here to be heard on those applications to be adjourned? Hearing none, a motion.
Mr. Chairman, I'd like to make a motion to adjourn the items read.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, we'll now move on to Part 3 of the agenda. Item 12, number 1056A, excuse me, Pinecrest Estates. The applicant requests to extend the performance bond for a period of 1 year to expire on December 31st, 2012, in order to obtain more time to complete the performance bond release process. The applicant received conditional final approval for this two-lot subdivision from the Planning Board on January 18th, 2006. A performance bond estimate in the amount of $4,397 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted a letter of credit in lieu of a performance bond on December 31st, 2007. Planning board approval for this performance bond expired on December 31st, 2011. The engineering department contacted the applicant by letter dated January 18th, 2012, informing them the bond had expired. The applicant submitted a performance bond extension application to the planning department on February 9th, and the application was distributed to all departments concerned for review. The engineering, highway, and traffic safety departments have no objection to the performance bond extension request and have determined the bond amount is sufficient to cover all remaining improvements. Planning has performed an on-site inspection of the subdivision and has determined that all of the required public improvements have been completed. The applicant must submit a final as-built survey and a monument certification letter to the engineering department prior to the circulation of the town board checklist. Therefore, the planning department has no objection to the applicant's request. The planning department offers the following resolution for the board's consideration. Be it resolved that the planning board hereby approves a retroactive extension of the performance bond for the subdivision known as Pinecrest Estates, number 1056A, for a period of 1 year to expire on December 31st, 2012. Mr. Chairman, this is the Planning Department's recommendation for Pinecrest Estates, number 1056A.
Thank you. Anyone here representing the applicant? Could you give your name and address, please?
Peter Massaro, 18 Wexford Court, St. James, New York. I'm just waiting to confirm what they asked. I ordered the Mylar and the monument letter from my surveyor. As soon as I get that, I'll submit it.
You have no objection to the recommendation?
No, none.
Members of the board? Anybody in the audience that wishes to speak on this? Motion.
Motion to approve a retroactive extension of the performance bond for the subdivision known as Pinecrest Estates, number 1056A, for a period of 1 year to expire on December 31st, 2012.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda under Part 3 is item 13, number 1143, Gemini Landing. Mr. Chairman and board members, just to let you know, there is a typographical error on the agenda. Gemini Landing was listed under extension of performance bond, and it is in fact a final subdivision request.
Okay.
Mr. Chairman, this application was brought before the board on the March 21st, 2012 Planning Board meeting, at which time the applicant and his representative made their presentation to the board. The board did adjourn the matter for an on-site inspection, which I understand all of the board members did complete. The application is now back before the board for a final determination. It's my understanding that the applicant and his representative do wish to address the board prior to the board making a decision. Bless you.
Good evening. My name is Michael Morbillo. I'm an architect. My firm is Inspire Design Group. Offices at 1650 Sycamore Avenue, Bohemia, New York.
We haven't read the, you haven't read the essential part there of the application.
Do you want me to read the resolution onto the record? Yes. Okay. The Planning Department offers the following resolution for the board's consideration regarding the application of Gemini Landing, number 1143. Be it resolved that the Planning Board hereby denies the request of Gordon Osterjic to subdivide Suffolk County Tax Map number 11-7-3 as depicted on the plans prepared by Tremaine Eason, Land Surveyor, for the subdivision known as Map of Gemini Landing, number 1143, for the following reasons. 1, the request to access Berry Hill Drive by way of a driveway over 200 feet in length over a town right-of-way is not consistent with the plans for this area. It would require extensive regrading and unnecessarily deviates from the traditional access to this property that the board finds is suitable as access for the subdivision of the subject property. 2, there is a practical and feasible alternative design that will be less destructive of the environment. 3, there is a practical and feasible alternative design that would permit the adjacent property, Suffolk County Tax Map number 11-7-1.3, to also be subdivided. 4, the alternative design noted in points 2 and 3 is consistent with the design objectives of the subdivision regulations that recommend layouts that minimize regrading per 248-26, that are consistent with having a minimum impact on the environment per 248-28, and be useful for future development per 248-24. Mr. Chairman, that is the recommendation for Gemini Landing number 1143.
Yes, sir.
Okay, so
Your name and address, please.
yes, Michael Morbillo, architect, Inspire Design Group, 1650 Sycamore Avenue, Bohemia, New York. And just to recap from the last meeting, I understand that the board has had an opportunity to go out to the site and to examine the application closer. And so we're just following up very briefly this evening. We are still, since that time, we have reviewed some alternatives with the planning department as far as working out an access to Meadow Glen that would, work with the future development of my client's property. And we looked over the design that we had proposed for a driveway or a narrow road accessing the Berry Hill cul-de-sac. Since that time, based on the last meeting, we also had, and based upon some comments and discussions with the engineering department, we looked at some of the factors related to the development of Berry Hill, which had come up at the last meeting, and also the legality or the ability to access Berry Hill. And I just have two brief items just to submit to the board, which were based upon that last meeting. The first one is actually just an as-built, and again, I promise I'll be brief this evening. It's the as-built plan of Berry Hill, and in the as-built plan, one of the issues that had come up was the ability to connect to Berry Hill and the the improvements and how much that was going to impact the environment. And just one point that I want to make was that and I had asked the board to look at the minutes from the last, from the Berry Hill subdivision, was that the Berry Hill plan was designed with the intent to extend a road. And initially, since we didn't have much guidance from planning because they were opposed to the application, we were proposing a driveway to access across the Berry Hill right-of-way. What we're changing in our proposal from the last time is that we're now proposing a road across the Berry Hill right-of-way with a P turnaround at the end. And that would be a road that's consistent with the rest of the Berry Hill development, which is a 25-foot wide road with a turnaround. And the reason why we're doing this is, again, going back to the minutes and to the proposals from the Berry Hill subdivision. The Berry Hill cul-de-sac was designed with a notch, which is highlighted in blue on the as-built plan. And also, the drainage was placed at the end of the cul-de-sac in such a manner to allow for this future extension. So it's still our argument, and for your consideration, that it was intended that a road was to continue. If it hadn't been intended, then that notch nor the drainage would have been designed in such a manner to allow a road to come across there. As I think has been presented, that it was the intent that due to topography and other matters that that area not be constructed. But upon further review and some discussion with the engineering department, because they had similar concerns, it's shown that that drainage was placed in a way so that a roadway could cut across. The last item that I'm going to submit is it's actually it's a case law for the state about the rights for my client to access right-of-ways. And certainly the purpose of a right-of-way is to build a road over it. And this right-of-way has not been, it's on page 6 is an area I had highlighted. The purpose of the right-of-way was to build a road over it. And just because a road hasn't been built doesn't mean that my client isn't allowed to build a road. The right-of-way has not been condemned. If the town thought that that right-of-way was not needed, then I think they would have looked to condemn it, but that hasn't happened. And the case that I've submitted is Stuart Podolsky versus the town of Brookhaven. They had similar matters where they weren't looking to, they wanted to go across, access his property from a different direction where he had access to basically what was a paper street, which is what we have. And the area that I've highlighted is an area where that case was actually ultimately was approved, and they said that the owner was entitled to access a mapped street, and that it's his constitutional right under the state of New York to access that right of way. And in there they reference at least 3 cases, which was West Center Congregational Church versus East Smithtown and Borducci. I'll spell it out: EFSTATHIOU, and Borducci versus the city of Yonkers, and then DeRusio versus Jackson, and Fisher versus Liebman. And these were all matters in which somebody, the owner wanted to access a paper street or wanted to access a right-of-way. And since that right-of-way has been established and hasn't been condemned, we would, and since it appears with the as-built and the previous design, it was the intent of the town, my client feels that he has a constitutional right under the state of New York to have access to that right-of-way. Again, since I mentioned the last one, that he has frontage on it. What I've illustrated here is a modified design with a P cul-de-sac, which was considered at the Berry Hill, the Berry Hill design review meetings for the subdivision. We're proposing that we would construct a road to town standards. I'm submitting this to the board tonight because I feel that it should be considered. I also, before making a decision, and I'd also ask, I'd mentioned at the last meeting but I didn't ask for a motion for the minutes from the Berry Hill meetings to be included, and those were from September 6, 1995, April 5th, 1995, and April 19th, 1995. We asked that, for a motion that those be included into this record for this board's consideration. I wasn't sure if the board had an opportunity to review them since the last meeting when we had mentioned them, but, Mr. Chairman, I would ask for a motion that they be incorporated into the record. You do? Okay. All right. Okay. Yes.
Are you finished with your presentation?
I'm finished at this time.
Okay. Frank?
Mr. Chairman, may I address that matter? First, with regard to the minutes, the minutes do not have to be attached to this. They are approved by this board, and they are your official records. So whether they are a year ago, last week, or 10 years ago, they're all part of the record, so there's no motion that's necessary for that. The second issue is that I think it's being ignored, which was explained at previous meetings, why we placed the cul-de-sac at this particular location as opposed to the original approval. I will reiterate one more time that the original plan that we had when Berry Hill was done was to connect Berry Hill Drive to Meadow Glen Road. In the process of doing the subdivision, after the preliminary approval, we realized that that was not a good alternative, and we decided to amend the approvals. And the approvals with Berry Hill are all consistent with that conclusions. One of the reasons for the shortening of the cul-de-sac was there's a memorandum in the file, and I believe I read this on the record, but I will reiterate it. The highway superintendent said that if we placed the cul-de-sac at the bottom of that particular hill, he would have problems in snow removal and bringing his trucks back up that hill during the wintertime, and he recommended the shortening of the cul-de-sac. I will probably reiterate that the current highway superintendent will probably say exactly the same thing, which is one of the reasons why we didn't build that cul-de-sac the way the subdivision was done. The second item was we abandoned, and we could have accepted, the right-of-way for the remaining portion of that particular access to the Bogey house. Rather, we gave that to the Dolans with the proviso that that would be best for their future subdivision of their lot. Again, this is the lot that's across the ways, and we deliberately gave that land for access for the subdivision of the properties on the opposite side of Berry Hill. Now, with regard to legal cases and access for roads. Paper streets generally are considered those subdivisions that were approved prior to the enactment of subdivision regulations. Subdivision regulations were enacted in the 1940s. And what is different about subdivision regulations and the streets that are created with those regulations versus old file map paper streets was that there was no regulation of paper streets, except that everyone had a right to paper streets. So where you have the old grid subdivisions, like in St. James or Kings Park with north, south, east, west roads, where they're not built, people have a right to open up those particular streets because they're grandfathered in subdivisions. However, with the enactment of subdivision regulations that were started in the 1940s, one of the key provisions of that is that this board, the planning board, is to exercise its judgment on the placement of roads in a given area and the feasibility of roads. That is not only in the regulations, but it is in in the law, but it's also in our regulations. That is your role in the deciding factor in this particular area. This board will render a decision as to what is suitable for the area. That is what you are charged with by the town board. It is your judgment as to take the advice of the professionals or anyone else, the citizens of a given area, or any way you wish, and to make a decision as to what you determine is the best location for the road system in a given area. You have the power what is known as the official map power, which is the power to designate what roads should be opened and what roads should be closed. That is your authority as to what you may wish to do. This is not an issue with regard to paper streets. And I would say that, we have gone over this thing ad nauseum in terms of what has been the most appropriate development for this particular area. And if this is what the applicant wishes to present at this particular moment, I would say that this was debated. When we did the Berry Hill subdivision, it was determined by all the parties involved that it was not suitable to bring that cul-de-sac down to this particular level. There has been nothing that would alter that disposition since that time was made. And, we have suitable options for the gentleman to subdivide his property. I wish to stress on the record here, since the record is so important, that this board is not denying somebody the right to subdivide their property. This board has said repeatedly that you would support a two-lot subdivision in that particular area. What this is a question on is where the road is going to access this particular property. And that is solely the power of this board. Not even the town board could question that particular authority. And this board, I believe, and excuse me if I'm getting passionate about this, but this is something we've had 4 meetings on. This is something which we've gone over the record meticulously on and documented why we did every step along the way we have. So if at this point, my recommendation as the planning director, that I don't want to have another public hearing on this. I think we have done this. I think if this is what the applicant wants and is presenting this and did not even have the courtesy to submit to us this particular proposal before this meeting, I am asking the the planning board, to accept our resolution.
You haven't passed on this proposal yet?
What's that?
You haven't seen this proposal
No,
yourself?
this is the first time we're hearing about this proposal, and what the applicant is doing is I know exactly what he's doing. He's building the road to town specs because we have recommendations from town, specifically, I believe you have it in front of you, Adam, the highway superintendent, who will not support building a road in a public right-of-way. And so the applicant is now proposing to build the road that we said 10 years ago we didn't want to build because it was not suitable for the highway department at that time, and we deliberately shortened this particular road for that particular consideration. We've gone down this over and over again, the same issue. And in fact, the Dolans came to this board and said to you that they tried to do it 5 years ago, and we told them that they couldn't do it at that particular time. How many times do we have to revisit this particular issue?
Okay, but we're not looking to,
Wait,
yeah,
excuse me.
sure,
Wait
yeah,
a
I'm
minute.
sorry.
Right.
Yep,
One person at a time, please.
yes, sir.
Go ahead.
At this time, Mr. Chairman, that Mr. DeRubius has read his recommendations, would,
Don't make anything until I hear through the audience.
Okay.
Okay? Is there anybody in the audience that wishes to be heard on this proposal?
I don't think he's
I
finished
don't
yet.
think he's finished, Mr. Chairman.
Are you finished?
No.
Okay, go ahead, finish your presentation.
So, just, listen, we're not ad nauseum. We would have much rather this been one meeting with all this, so it's not our intent to have ever extended anything out. Mr. DeRubius has never been able to explain that why, if the subdivision was not meant to extend the road, why would they go to the extent of installing the drainage on the road and the notch for a continuation if it was just a design speculation? Why didn't they just end the cul-de-sac and put the drainage in a better spot as opposed to putting easements for drainage? He hasn't explained that point, and we're not the ones that have dragged this out. We've consistently said why we think that this is a better application. He stated his reasons why, and that's why we've brought this before you this evening. It's not for last minute. Times, it does take time. This board had to go out and look at it. We're not looking to extend it. We wanted to give you time to be able to go out there and render a proper decision. If the board feels they're able to render a proper decision tonight, then we will go with we have to accept your decision. We felt that this was important to present because this does come down to, and we were able to make a full presentation at the last meeting, this comes down to that we feel that the Berry Hill is a better application, it's less destructive, and that my client has a right to access that right-of-way. That's where it comes back to. We still haven't, we had discussions since the last meeting. We tried to do our due diligence to say, okay, let's look at how we might access Meadow Glen, how that might be developed in the future. And it was still problematic. We know we have rights to cross that property, but as far as developing it and maintaining it, there are still issues there that we feel are going to be problematic in the future. So it's still private land. They don't own it. And I will add on to this to reiterate that we would be happy to meet with the Dolans. When Mr. DeRubius had asked us to meet with the Dolans, they showed a proposal by their surveyor to extend the cul-de-sac down Berry Hill. They were never told no in front of this board. They were told no in Mr. DeRubius' office, not in front of this board. They did not ask for it. And this has been dragged on, not by our doing. We're trying to present the information and have this back and forth. We're not doing this to try and belabor or try to waste this board's time. So we presented what we feel is very important and pertinent information, and we understand respectfully that Mr. DeRubius says his approach. We disagree. That's why we've come before this board. So
Okay.
yeah, that's it.
We've had 4 hearings on this so far,
Yes.
okay? So that now we want to make some kind of a decision, and we want to listen to the audience that wants to talk on this application and hear them for the record. Anybody in the audience that wishes to be heard on this? Anybody? Okay. Board members, a question?
Mr. DeRubius, is there any precedent, either before this board or any other board in the town, for allowing an applicant to pave over 200 feet of town-owned property?
Well, I believe he's changed his proposal now.
Okay.
What he's doing is he's proposing in his new proposals to build a road. Instead of building the 16-foot wide driveway that he's proposing, which is the 200 feet, which I think addresses your question, what the applicant is now proposing to do is build a road, and that's what he is presently offering to you at this particular meeting. And what my response to that was, we shortened the cul-de-sac in this particular location, specifically on Highway Department's request, that the slope would be too much for his trucks to remove snow, and it was unnecessary for him to have this particular road.
But if they're going to pave the road, how much of town property would that take up?
Well, they're going to pave it as a road then.
Okay, but how much town property are they taking?
Well, they're taking it all.
The whole thing?
Yes.
In feet, how much?
225 feet, somewhere around there.
And the road is going to go from the court to where?
To the P shape would be where you're looking at the, if you're looking at that area at the bottom of where the word Berry Hill begins. That's where it would end.
So it's just as much devastation, maybe even more now.
It's more.
It's more, because now we're making it wider. It's a larger area, and we're going to actually ruin whatever is there.
And Frank, so what this, if I'm reading this correctly, it's going to stop at a P shape, and they're going to still have to go out on the original roadway that they have access to, correct? They're going to be turning you that as a turnaround?
No, from what we don't know what their plan is just seen there.
As this is shown to us, it's not full access through, it's a turnaround, correct?
The new plan.
The new plan.
The new plan is it appears that both homes will access Berry Hill. That's that plan that I'm looking at from here. And that's the closest I've come to their plan thus far. That's what I see. Well, they're probably, what they're asking for, and this is what's going to be the problematic, is that the town's going to have to accept dedication of this particular road. And the point that I made in previous things is the highway superintendent did not want a cul-de-sac, a slope down to a cul-de-sac, because he said his trucks were going to have a problem going back up, which means, and this is a problem that we have, is that the highway superintendent, it's still his call as to whether to accept the dedication of a road.
But I'm saying this plan,
Which,
the
okay,
new proposal,
right.
or the proposal we just saw today, this does not have access to the Berry Hill cul-de-sac as the cul-de-sac currently exists on Berry Hill?
It's, what he's doing is extending the road.
But what I'm saying is that there's no access going through, correct?
Correct.
To Meadow
I'm sorry.
Glen.
There's no access going
There's
through?
no going through to Meadow Glen, no.
Is
It would
this-
end at
No,
the edge of my client's
excuse me.
property.
So there's no access that you are proposing now to go through to the cul-de-sac, correct? You're proposing it as a turnaround?
There's already, there's a turnaround there, on the cul-de-sac. What we're proposing is to extend the roadway where the notch is right now to a P cul-de-sac at the end. And
Okay.
so, yeah, this is a newer proposal.
We'll take out more.
Two
Okay.
questions. Is this proposal properly before us, number one, to act on?
Well, if the board wishes to consider this, then I would say we have to submit it back for the other departments for comments and review.
Number
If-
two.
if-
That's reasonable.
Are,
I don't think it's reasonable, because we've already answered this particular, I'm sorry, Adam, we've already answered this question at previous approvals. And I think this is, I have to really object, because we've gone over this in terrible detail, more detail than I could imagine, in terms of basically showing that this gentleman has alternatives to develop his particular property. This board is not trying to prevent him from having 2 lots. What we are discussing is what is the best road. And that, I think we have all agreed that the best access is off of Meadow Glen. That's what this is all about. We're not prohibiting a gentleman from getting a return on his property. And I apologize, Adam,
No,
for
it's okay.
interrupting.
Which has been his current access since 1996.
Just to speak to that point, too, yes, it keeps coming back to the road. Mr. Derubius will disagree. We believe this is a safer access to his property. Right now, they have to go 600 feet to go down a driveway to get to his house.
what about the other people in the court who don't have a road there now?
The other people, it's going to be 2 more houses on the end. I mean,
But
that's
he's
the
currently
addition.
They don't have
using
road
another
there.
road.
They don't have to deal with any road right now. They have beautiful, pristine woods.
So did my client at the time, but what we're looking to do is where that notch is already, to extend it down. I submitted the last meeting what the impact of that would be.
But he's been using Meadow Glen since 1996.
Yeah, on a driveway.
But
and
he's
it-
been,
yeah.
and he bought the land in 1996, knowing that was the access.
He also had access through the Woodhull at the time, correct?
But he bought it in 1996, knowing that Meadow Glen was the access that he had in and out of his property.
Correct. And as I
Okay.
stated at the last meeting, he also had access to Woodhull.
We're not talking
Yes.
about what.
We're
about
proposing
Wood-
that this is a
Woodhull.
safer access for emergency vehicles.
But he's been using that since 1996.
Correct, and it's been problematic since Berry Hill has been established. It's been problematic for the last 17 years.
Well-
That's why consistently we're coming back with
Were
that.
there any complaints registered about the problems?
The problems is a matter of safety. My client almost lost his fingers. He's had problems with the driveway access across the easement. He's had several
But when he
problems over the
bought
years.
it in 1996, please, I don't want
Yes.
to belabor
Yeah.
this. When he bought it in 1996, he knew that was the access.
Before Berry Hill was developed.
But he knew that was the access.
He knew he had 2 access, yes.
So no, he had one access.
He had access to Wood Hollow, and he had access to Berry Hill,
Okay.
to Meadow
All right.
Glen. He lost access to Wood Hollow.
But he's been using Meadow Glen.
He's been using it at that time, knowing that someday he would come before this board with a subdivision application. So when Berry Hill was
So he
established,
bought the property with somehow looking at one day he was going to change the way he went in
no,
and out of
of
the
course,
property?
yeah, he knew he bought
That's
it
a
to.
big gamble.
Well, it's an investment
It's a
too.
big
He bought
gamble.
it 2
But
and a half
that's a
acre.
big gamble.
No, I don't know if it's a gamble.
Oh.
He saw Berry Hill go up, he saw an opportunity, and he saw what would be a much more desired approach to his house and a safer approach with a full road to his home as opposed to a 600-foot,
But
8-foot
that
wide
was
driveway.
back in 1996.
Correct. And when he saw Berry Hill going up, he
Okay,
knew
so
he had
this
an
is
opportunity.
2012.
And we came to this
All right.
town in 2005. Yeah, that's when we came. So
Do you feel you've had a fair opportunity to be heard here?
absolutely,
Okay.
absolutely,
And you know we've been to the site twice?
absolutely, yes.
And have you presented all the information that you want to present to us?
Yes, we have.
Okay. Any other questions by the board? A motion on the recommendation of the planning director.
In the matter of Gemini Landing, number 1143, motion to adopt the resolution as read, in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Aye, aye.
Opposed?
Opposed? Aye, aye, aye.
I'd like also to make a motion to incorporate any additional information that was presented into this hearing tonight for consideration of this resolution. I don't know if somebody wants to phrase it more articulately, but I think a motion should be made to incorporate what's been presented here tonight.
All right, is that the motion?
That's my motion.
Second.
All those in favor?
Aye.
That motion.
Opposed?
That motion, to incorporate everything, I'm in favor.
Okay,
The resolution, I'm against.
okay. We thank you.
Thank you very much.
you.
I appreciate your time greatly.
Okay. Okay? Adam? Please?
Mr. Chairman, we'll move on to item 14 on the agenda under Part 3, the letter of interpretation for Ryan and Breslin. The applicant is requesting a letter of interpretation from the Planning Board pursuant to Section 323-11 of the Town Code for a property identified by the Suffolk County Tax Map as 6-1-6 and 7. The parcel consists of 2 lots in the R43 zoning district, 43,560 square feet minimum lot area per dwelling. There is a single-family dwelling as well as a swimming pool, greenhouse, detached garage, and 2 sheds on the property. The parcel has some steep slopes and is densely wooded. Lot 6 is owned by Fort Salonga LLC, and Lot 7 is owned by Maymark LLC. Maya Ryan, the applicant, is the manager of both corporations. The purpose of a letter of interpretation is to determine the number of density flow rights that may be transferred from a given parcel. Section 323-9A and B cover the calculation of density rights for this parcel. It should be noted that the applicant is proposing to modify the lot lines of the parcel to make the tax lots more conventional in shape, as shown on the sketch attached to the back of your memorandum. Presently, Lot 6 forms a horseshoe around Lot 7. Excuse me. As the subject parcel is not part of a filed map, a modification of lot lines does not require Planning Board approval. With respect to subsection A, the parcel is located in the R43 zoning district, which requires a minimum lot area of 43,560 square feet or 1 acre. Therefore, one density flow right corresponds to a parcel or area of at least 1 acre. With respect to subsection B, the applicant submitted a reasonable yield plan that demonstrates that the parcel can be divided into 23 parcels, 21 vacant parcels, 1 parcel with the existing dwelling on it, and 1 parcel for a 2.31 acre recharge basin. In reviewing the yield map, it appears that the recharge basin could be reduced in size, which would create another or 24th parcel. Therefore, based on our review, it appears that there are 22 density flow rights, or 6,600 gallons per day, available to be transferred from the property, 6 on the proposed southern lot and 16 on the proposed northern lot, plus an additional density flow right of 300 gallons per day on the northern lot if the existing dwelling were to be removed. The Suffolk County Department of Health Services has reviewed this application and has confirmed that the yield of the parcel would be 23 rights, 1 of which is used by the existing dwelling, and 22 of which are available for transfer under the town's program. After reviewing the documents submitted with the application, the Planning Department is prepared to recommend that the Planning Board issue a letter of interpretation indicating that there are 22 rights available to be transferred from the subject parcel, plus an additional right if the existing dwelling is removed. However, if the board may wish to adjourn this matter in order to inspect the property. If the board wishes to act on this matter without an inspection, the Planning Department has prepared a resolution for the board's consideration.
Thank you. You representing the applicant?
I am.
Please give your name and address.
Good evening. My name is John Breslin. I'm an attorney with offices at 44 Elm Street in Huntington, representing the applicant, Maya Ryan, who's the managing member of both the two LLCs, Fortzonga LLC and Maymark LLC. Just, there was a little bit of confusion in the numbers that it was read. I thought you indicated originally that there were 23 and then indicated that there was 24, because there was an extra one. So if my math is correct, there would be 23 plus the house. Would that be correct?
Okay, basically,
That includes Lot 6, is that what you're saying?
Including, the overall, there would be, initially, I think, just to paraphrase, I think the initial determination that there would be 23 with the potential for an extra one because the sump was too big.
that's correct.
So that would make the total available 24 with one for the house.
That's correct.
Okay.
However, your application, I believe, was for 22.
Well, actually, we made the application
I
for
mean-
the total amount that would be available. I think you make the determination, we don't make it.
Well, it's based upon the maps that you submit to us. We respond to the maps. If
Okay.
you wish to, we say that you have eligibility for 20, actually 24 with the existing house.
Okay.
The maps that was presented to us show 23. So we're giving you what you asked for, but you could ask for another one, is what we're saying.
Okay, well, obviously, we would prefer to get as many as we possibly can. And the reason we're here is my client has owned, and her family have owned this property for many, many years. And her intent, or her goal, is to try and preserve the property. They'd come to the point where they couldn't afford to maintain it any longer, so they were thinking of selling it. This program came available, and this is an opportunity perhaps for them to be able to generate enough economic revenue from the sale of these density credits so that they'd be able to maintain the property and not have to sell it and subdivide it. So that's the goal. So the idea of getting as many density credits as possible would enable them to do that, and so that they wouldn't have to develop the property. One suggestion I have for this program, which is a wonderful program, and it does present this available thing for people who want to preserve their property, is in the design of your sign. The sign that you put on the property says subdivision, so that neighbors and people who see the sign have no idea that somebody's looking to preserve the property.
Looks like they look at the subdivider to put houses on there.
Precisely.
Hence the reason that we have people, yeah.
So all these lovely people who probably have wasted their time are afraid that my client is chopping up these beautiful 38 acres into houses. If they had known that she's looking to actually preserve those 38 acres, they may not have wasted their time to come here tonight. So perhaps in the design, we could come up with a new design of the sign so that people would know that.
I have a question there. It's quite a large parcel.
Yes, it is.
And these people, naturally, they are probably neighbors to that parcel.
I'm sure they are.
How are you going to secure that parcel so that it's not abused?
Well, my client lives there.
I know your client lives there, but once you get those rights,
The idea would be so that she could continue to maintain the property. I mean, the purpose of doing this would be so that she could raise the funds necessary so that she can continue to own the house, keep the house, and stay there. That's been her goal all along. Unfortunately, she's come to this a point in her life where she doesn't have the funds available to continue to maintain that large property. So the idea of going through she's looked into and even started the subdivision process, hasn't found it to work to her liking. She doesn't really want to. The reality is she doesn't want to subdivide it. She doesn't want to do it. So when we came upon the possibility of doing this, we feel that economically it would give her the funds necessary to be able to maintain the property, stay there, and as she needs funds, sell off development credits.
now in the event that she
And her family. When I say
passed
she,
away, or-
when I say she, I mean her family.
Yes.
She has two daughters. and they're very much a part of this process.
Is this a trust?
It's an LLC. The daughters are also members of the LLC, so they are very much involved in this decision-making process and are all for it. They would like to see this go as well. They're not looking to sell it and get as many dollars as they can out of it, obviously, by looking for this process. As you know, the property would have restrictive covenants on it, and that would impair the ability to subdivide it and develop it. Even if at some point there was a change in what they wanted to do, if they were to sell off the development credits, then obviously that portions of the property would be restricted. So, you know, this does give them an option to be able to preserve the property, and that would be the goal. At this point, that's what they're looking to do. And the hope is that there's enough of a market for these credits that economically it would provide the viability to do it.
Any questions from the board directed to the council?
I
please?
just have the one question, if I may, to Mr. DeRubius and the staff. Do we need to refile a new map, shortening that, making the sum smaller?
Yes, I didn't make myself clear. Before we come to this board, we contact the health department. They see this particular map and they give us a number. We base our recommendations based upon that number.
Okay.
So if you wish to do that, I have no problem with modifying it, submitting us a modified map, showing based upon the suggestions of staff, and then we will bring it back before this board, but we will adjourn that matter this evening then.
Right. Would you anticipate the health department would have a problem with the modified map?
No, they respond to exactly what they see.
Fine. Okay, then I think that would be, from our point of view, the extra development credit would be something that would be important, so we would want to do that.
Okay.
Thank you.
Going to adjourn it?
I would recommend, if that's what they wish to do, I would recommend that, yes. And the board may wish to, the board's practice in the past has been, we didn't know, some sites you did an on-site, some sites you didn't. It's the board's, if you're going to adjourn it, you might as well do an on-site.
You're clearly welcome to come to the site. I think you'll find it's a magnificent piece of property. My client would love for you to see it.
Is there anybody in the audience that wishes to speak on this? If there is, let's take it in an orderly fashion. Okay? Start from the left and we'll go to the right. Just give your name and an address when you come up, please.
Good evening. Linda Henninger, 1 Meadowood Lane, Fort Salonga. I live directly across the street. Henninger, 1 Meadowood, Meadowood Lane, Fort Salonga. I wholeheartedly support this application. And if I can't make it the next time, I hope you still remember that. We think it's a wonderful thing they're doing. And it's beautiful property, and they keep it beautifully, and, you know, we support it.
Is that what you expected to say tonight?
Kind of. Thank you.
Okay. Anybody else in there? In here? Okay. You gentlemen here. Give your name and address, please.
Antonio Gerasi, G-E-R-A-C-I, excuse me, 57 Fort Salonga Road, Fort Salonga. I wasn't going to say anything tonight. I just wanted to get a better understanding what this was all about. But I am the president of the Fort Salonga Association, and I can't really emphasize enough how important this would be for the Fort Salonga community to have this parcel of land preserved as it is today. And I am very encouraged that the owner of this piece of property is of the same mindset that she would like to see it preserved, continue to live there. And I hope this board takes that in consideration. I think it's a very important consideration. It's something that we don't find very often, that somebody's willing to have their property preserved so that it can remain a viable and open space part of the community. Thank you.
You're welcome. Yes, sir.
Good evening. I'm Paul Graff, G-R-A-F, 48 Orchard Drive, Fort Salonga. I want to say, first of all, applaud the Fort Salonga. I'm a member of the Board of Directors of the Fort Salonga Association. We have been working behind the scenes to quietly talk about ways to preserve areas in Fort Salonga. Our position has always been one house, 1 acre. One house, 23 acres is a better deal for everybody. It helps protect and preserve Fort Salonga. We certainly urge the board to approve this application for the density credits. That would be a great thing for our community. Thank you.
Thank you. Anybody else? Yes, sir.
Good evening. My name is Ion Azola, I-O-N, last name A-Z-Z-O-L-A, and my address is 126 Fort Salonga Road in Fort Salonga. And we are one of the neighbors of this property, and I'm very happy to support the nature preservation and support also the preservation of this wonderful property. So I hope that everything is going to work out well, and we're going to enjoy that area for a long time. Thank you.
Thank you. Anybody else? Any questions for the board? Does anybody want to do an on-site before they vote on this? On the board?
Well, we need to adjourn it
It's going to be
anyway.
adjourned anyway,
All right. Adjournment for an on-site?
and also to submit the new map, right?
Right. We'll have it done.
Adjournment for an on-site.
In the matter of LOI-6, Meyer Ryan, motion to adjourn for an on-site.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered. You understand what we're going to do? We're going to do an on-site and get them to correct the map. Okay? We thank you. And if you could just, we have other stuff on the agenda here, so if you just would leave quietly, you can talk out in the hall if you want. And thank you. Please.
Mr. Chairman, we'll now move on to the next item on the agenda under Part 3, Item 15, the Letter of Interpretation application for Summer and Heller. The applicant is requesting a letter of interpretation from the Planning Board pursuant to Section 323-11 of the Town Code for a property identified by the Suffolk County Tax Map as 18-7-6. The parcel is located on the southeast corner of Oak Road and Dahlia Drive. Both of these roads are paper streets. The subject parcel is located approximately 88 feet east of the nearest paved road, Daisy Road. The parcel is 10,580 square feet. Is a 10,580 square feet lot in the R10 zoning district that requires a 10,000 square foot minimum lot area per dwelling. The lot is vacant, has steep slopes in the northern portion of the property, and is wooded. The subject parcel is owned by the DeLeo Family Trust. The purpose of a letter of interpretation is to determine the number of density flow rights that may be transferred from a given parcel. Pursuant to Section 323 of the Town Code, the number of density flow rights for a parcel having an area of less than 20,000 square feet that the Planning Board finds is a pre-existing lot shall be 1. The definition of a pre-existing lot is a parcel that, A, is exempt from Article 6 of the Suffolk County Sanitary Code pursuant to Section 760-609 of the Suffolk County Sanitary Code, and B, either meets the minimum lot area and frontage required by Chapter 322 zoning of the Town Code, or has not been held in the same effective ownership as any contiguous parcel at any time since the date the parcel became substandard under Chapter 322. With respect to A, the Suffolk County Department of Health Services has reviewed the application and found that the parcel is exempt from Article 6 of the Suffolk County Sanitary Code. With respect to B, the parcel meets the minimum lot area of 10,000 square feet and frontage of 75 feet for the R10 zoning district. The parcel is 10,580 square feet and has 94 feet of frontage on Dahlia Drive and 147 feet of frontage on Oak Road. Therefore, it appears that the parcel meets the chapter's definition of a pre-existing lot and has one density flow right available to be transferred. The Suffolk County Department of Health Services has reviewed this application and has confirmed that the parcel has one density flow right available for transfer under the town's program. After reviewing the documents submitted with the application, the Planning Department is prepared to recommend that the Planning Board issue a letter of interpretation indicating that there is one right available to be transferred from the subject parcel. However, the Board may wish to adjourn this matter in order to inspect the property. If the Board wishes to act on this matter without an inspection, the Planning Department has prepared a resolution for the Board's consideration. Thank you.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. Obviously, I'm in favor of the recommendation of the Planning Department and the Health Department. I wish my client had 38 acres and was going for 24 development rights, but all he has is a quarter acre. And if these people are here tonight and they listen to Mr. Breslin, I'll just say it fast. The property is not to be developed. In this case, we're going to give the property to the town, and it'll remain vacant. Thank you.
Is there anybody here that wishes to speak on this application? Do you understand what's going to happen?
There's a
There'll
gentleman.
be no development on that property. The what? Would you come up to the microphone and give your name and address, please?
Hi, Deb Foster, 35 Daisy Drive, Kings Park. So what happens to those paper roads? They're abandoned then, or?
Short answer to the question is not yet. We're trying to get them abandoned.
Okay, so
Okay.
if this goes through, then that would
That'd be
happen?
one of the steps towards eventually. There's multiple property owners that are in that particular area. I'm very familiar with this. This has
I
been
just
going-
went to the town assessor, it's one owner.
No, along the roadway, along the two roads. There's Oak Road and Dahlia.
Right.
Okay, so they're different owners.
According to the assessor's office, it wasn't today when
It
I
was at
went.
different properties then. And we have to get permission to abandon those particular roads. Our intention is not to build them.
Okay,
That's what our intent is.
all right.
But in order to abandon them, you need permission from all the
All
adjoining
the-
prop.
Okay.
We will have I have the map before me.
Yeah,
This
I-
property only fronts on portions of that road.
Right.
Okay,
And
so
I
this
went to
is-
the assessor's office to look at the map on the other side that's on Grove, on the other side of Oak. And that was also DeLeo that owns it.
Yes, but what we need is separate, actually, we need, I think it's almost 5 people that have to agree to abandon those particular roads, or 5 lot owners.
Okay.
In order to do that. As it stands now, with this property gone, I think there's only one more property that's outstanding that we need to have records on that it's not going to be built on.
Okay.
And then we could abandon these particular roads if the town so chooses.
All
But
right.
we've been trying to abandon those roads for
Yes,
20
well,
years.
Hurry up on that then.
I'm sorry.
Okay, thank you.
Is there anybody else that wishes to speak on this?
Gentleman right here.
No, yes.
William Mascione, M-A-C-C-H-I-O-N-E, 112 Grove Road in Kings Park. I would like to support the proposal that was presented to the board.
Thank you.
Thank you.
Any questions by the board? All right. A motion there. Read the resolution for the letter of interpretation.
Okay. Mr. Chairman, the resolution for the letter of interpretation for Seller and Beller, sorry, Be it resolved that the Planning Board hereby issues a letter of interpretation that the board has determined the number of density flow rights available to be transferred from the subject parcel known as Suffolk County Tax Map Number 18-7-6 to be 1.
A motion?
In the matter of LOI-7, Summer and Heller, motion to issue a letter of interpretation determining that the number of density floor rights available to be transferred from the subject parcel is 1.
Second.
All those in favor?
Aye.
Opposed? So ordered. Adoption of the minutes.
Mr. Chairman, I'd like to make a motion to adopt the minutes for March 7th, 2012, April 4th, 2012, as well as April 18th, 2012.
Second.
All those in favor?
Aye.
Opposed? So ordered. The map there is for Essex Estates has been, the bond has been accepted and I've signed.
You have signed the map, Mr. Chairman.
You're all set with that?
Yes.
A motion to adjourn.
Motion to adjourn?
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered.